Hello, my name is Alvin Brown. I'm a tax attorney. Today I'm going to discuss the legislative history for offers and compromise as we presently know those rules. There are substantial changes to the rules in 1998 under the Internal Revenue Restructuring and Reform Act of 1998. I'm going to read to you a little bit here from the conference report that accompanied the IRS Restructuring and Reform Act of 98. And the legislative history, this conference report reflects the intent of Congress. So we have the statute 7122. We have this legislative intent as reflected in this committee report. So we have the statute, but the document of the committee report, and I just have a copy of it here, is highly relevant as to what Congress intended. And the IRS has to be consistent with the intent of Congress. So a lot of decisions they made can step over the line between the statute and what was intended, how the statute should be applied. The IRS just administers the law that Congress writes, and it's important to follow the intent of Congress. Starting with looking at page 287 of the conference report, it gets to offers and compromise, and first describes the present law and talks about the settlement that is the collectability, that is the liability, and it says the IRS manual provides guidelines for revenue officers to determine whether an offer and compromise is adequate. An offer is adequate if it reasonably reflects collection potential. So, anytime now that's the old law prior to 1908, and that law wasn't, that reasonable collection potential wasn't changed. The House bill is interesting. There's the House bill, the Senate bill, and the conference report. The House, so the conference committee report references the House bill, which said it was with regard to that they identified in this. I'm sorry, there's nothing in the House report. The Senate amendment to the bill did have a comment on the offer compromise rules, and they write on page 288, liberal acceptance policy. Senate, and that's the heading of that paragraph, liberal acceptance policy. The Senate amendment provides that the IRS will adopt a liberal acceptance policy for offers and compromise to provide an incentive for taxpayers to continue to file tax returns and continue to pay their taxes. That's the gut of this. And so anytime you're involved with the IRS in an offer and compromise, this Senate amendment to the conference bill is highly important. So if you think the IRS is going off their skull here with regard to extreme positions, they can't take extreme positions. They have to follow a level acceptance policy, and that would be in regard to the factual issues and the legal issues. Now, the conference report there's a House bill, nothing. The Senate report, liberal policy. The conference agreement says the conference agreement follows the Senate amendment with the following additions. First, they added suspension of collection for an installment agreement. Secondly, and I'm going to read this to you, the provision authorizes the Secretary to prescribe guidelines for the IRS to determine whether an offer and compromise is adequate and should be accepted to resolve a dispute. Accordingly, the conference expects that the present regulations will be expanded to permit the IRS, in certain circumstances, to consider additional factors other than that as to liability or collectability. So now they're suggesting let's consider things other than doubt as to collectability, doubt as to liability, and to determine whether to compromise the income liabilities of individuals. For example, the conferees anticipate that the IRS will take into account factors such as equity, hardship, and public policy, where a compromise of individuals' income tax liability would promote effective tax administration. Well, now that's the language that got into the IRS rules, effective tax administration, because that is supposed to take into account hardship and equity and public policy. Curiously, the Internal Revenue Manual says that the rules for effective tax administration will be followed for purposes of doubt as to collectability. So, equity and hardship. Hardship is supposed to be taken into account in offers and compromise dealing with collectability. The conferees anticipate that, among other situations, the IRS may utilize this new authority to resolve long-standing cases by foregoing penalties and interest which have accumulated as a result of delay in determining the taxpayer's liability. So there's a push here to the intent of Congress here is, hey, let's settle these cases. We don't want these long-standing cases. We want them resolved. The conferees believe that the ability to compromise tax liability to make payments of tax liability installments enhances taxpayer compliance. They're saying here, settling tax debt that enhances compliance. Well, I would agree with that because, as the Internal Revenue Manual says, the tax policy gives you a fresh start in collectability cases. In addition, the conferees believe that the IRS should be flexible in finding ways to work with taxpayers who are sincerely trying to meet their obligations and remain in the tax system. I want to repeat that because this is really important. The conference committee here, the legislative intent of Congress, says explicitly that they want the IRS to be flexible in finding ways to work with taxpayers who are sincerely trying to remain in the tax system. Anytime I talk to the IRS, anytime I deal with it, I reference the legislative history here. I reference the fact that Congress told the IRS, 1, to take into account hardship, 2, to be flexible in these cases. Accordingly, the conferees believe that the IRS should make it easier for taxpayers to enter into off-compromise agreements and should do more to educate the taxpaying public about the availability of such agreements. So, here, part of the legislative intent of the conference committee, which is what the IRS is supposed to follow. The IRS is supposed to be flexible, they're supposed to take into account hardship, and they're supposed to make it easier for taxpayers to enter into offer compromise agreements. So, what does this say? It says that Congress wants the IRS to be liberal in offering compromise cases, and most of them are doubt as to collectability cases. So, now, the IRS pushes against this. They don't read the code, they don't read the regulations, good Lord, they don't read the legislative history. But, when you're watching this video and you're getting a little education here, you can quote the Internal Revenue Service Restructuring and Reform Act of 1908, the conference report, where Congress is telling the IRS, be flexible, be liberal, take into account hardship, and make it easier for taxpayers to get into the offer compromise program. This ends my little talk about the legislative history. There was also a recent change where the 20% rule came in, and also the 2-year limit. They can't consider an offer compromise for more than 2 years, and that was a legislative change. The statute is 722 of the code. If you have any questions about these cases, we're strong advocates in these cases. We always write a legal memo when we send out an offer of compromise. It runs 5, 6, 7, 8 pages long that educates the IRS on these matters. My phone number is 888-712-7690, extension 106, ab@irstaxattorney.com if you want to email me. Good luck. You need any help, I'd be happy to give it to you. We do offer a free consultation. Thanks very much.